Now, again, you understand that I'm not bound to follow any recommendation, and that would include following the IDIP guidelines.
Yes.
I could sentence you all the way up to the maximum possible penalty, again, if I thought it was warranted. You understand that?
Yes.
Do you have any questions for your attorney or the court before we proceed?
Sorry.
And that's all kinds of fun today. Okay.
Sorry about that.
All right. So you understand I could sentence you to the maximum penalty?
Yes.
Okay. Any questions?
Just one. It's just kind of a math question. I just want to know if it's fictional or a fact.
Math is usually not fiction. But
Yeah.
it's math.
And yeah, so I'd just like to be explained, like, how the math works. So I'm pretty good at math.
You want me to get a math professor in here to explain it? Because I'm not a mathematician.
That's what he said.
That he's not a mathematician because he's not. Because quite honestly, we go to law school, so we don't have to do math. But we have to do math in our job. What's your question?
Just to know if this is fictional or factual.
I don't know what this is.
Would you like me to?
No, what is this, Mr. Keene?
Your Honor, I think it's made. The issue, and this brought up I'm with Ms. Anderson. Is he had a question about the grams per 100 milliliters?
Dude,
and
that's a scientific question. You can call up the scientists or the lab analysts that do that. I'm not in charge of that. And the legislature makes up the laws.
Okay.
I'm in charge of following and enforcing the laws.
Buckle up, guys. Today we are diving straight into the courtroom chaos where the stakes are sky high. Right from the start, the judge makes it crystal clear that the defendant could face the maximum penalty, setting the tension immediately. The defendant, curious about the math behind the blood alcohol test, questions the system, even mentioning AI measurements. You can feel the nervous energy as the courtroom gears up for a real showdown.
Okay.
So what's your question? You think that you were below the limit, above the limit, beyond the limit, how they came up with the limit?
According to this, I was not above the limit.
Okay, and that's like a AI chatbot thing, right?
Yeah. So
Yeah.
Maybe it's wrong. I don't know.
Yeah, it is.
An AI chatbot?
But
Are we using artificial intelligence?
it's just that I was measured in thousands, and the law goes by hundreds.
We can have a trial if you want.
I am so great to have a trial. I love having trials, especially when the lab analyst comes, and especially when then it completely opens up to the maximum penalties. That's great and fine with me. Is that what you wish to do, and have a lab analyst up here to explain all of the scientific reasoning behind the calculations and behind their testing?
Just take me to jail.
Okay, I think that's his way of saying he's not rushing to press the point, Your Honor.
All right. Okay. So now, did you review the criminal complaint with your attorney? And it has all of those facts that says what happened that day from the officer's perspective and from your perspective, because you said, I only had 1 or 2 beers, which we know isn't factually true.
No, I had 0. I had drinking the night before.
Now things get heated. The defendant challenges the lab numbers, debating whether the decimals reflect fact or fiction. Every line of dialogue escalates tension as he argues about thousandths and rounding errors. The judge calmly explains the laws and scientific procedures, while the audience witnesses a battle of logic versus procedure. Suspense builds because the outcome of this argument could determine the entire trial's direction.
Then you drank a lot more than 1 or 2 beers the night before.
I had a six pack of 16 ounces and a 16 ounce.
And yet you blew a .221, allegedly in the criminal complaint.
Yeah, and that's what I'm saying is that 221 is thousands, not hundreds.
Oh, Mr. Lamprecht, it's .08 in Wisconsin to be legally drunk. And for 1 or 2 beers or a 6-pack or whatever you said the night before, unless you are a chronic alcoholic who drinks all the time, you won't wake up the next morning to blow a .221. It's impossible.
Exactly.
But you did. And we have lab, right, Mr. Renicky?
We have a lab.
What does lab say? Where they tested it with scientific stuff.
I didn't mean to put you in a bad mood.
0.19. You did by starting by being late.
I
Okay,
apologize.
you're not supposed to be late to court. Okay, you're supposed to be here early so you can meet with your attorney. And quite honestly, and it's taken you months and 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 months to do the IDIP program. I gave you yet another chance, and now you're here debating.
No, I'm just
Science.
saying, anytime you put a numeral behind the decimal, like 1 numeral behind the decimal is a tenth, 2 numerals behind the decimal is a hundredth.
Yep.
3 numerals behind a decimal is 1,000.
Here's where the tension peaks. The defendant pushes for a jury trial, wanting lab analysts to prove the math and science behind his blood alcohol levels. The judge carefully lays out the legal options, clarifying what a jury trial entails. This moment perfectly shows the clash between legal expertise and personal belief in numbers, keeping viewers on edge as they wait to see if he will go through with the trial or concede.
Yep, I know math.
Okay, and 1,000th is 10 times less than 100th.
Well, let's cut that off, okay? You blew a .22 with a PBT.
221.
Or .221, okay? So let's say you will cut off the 1, because that's what math does. You get to cut off certain things. So you were .22. We'll give you the benefit of the doubt. No more with that 1, that 1,000th, gone. So you blew a .22. But lab came back and said, guess what? We ran his blood, which is more accurate. And it gave us a better truth of what happened. And it was 0.19. It's .08 in Wisconsin to be legally intoxicated and operate. So you get it now? You understand now?
I don't understand how 1,000th is 100.
I cut it off. I agree with, I'll give you the benefit. I cut that off. It's .22. It's .22.
But no, if there's 3 numerals,
Yeah, I
because
think
if it was point,
Mr. Renicky, I'd love to have a jury trial because it sounds like he doesn't understand the science and he wants to have a lab analyst here. Is that right, Mr. Keene? Is that what I'm hearing? He wants to have a jury trial because we can facilitate that next week.
I'm just saying what math.
The defendant finally makes a bold decision. Just take me to jail. After hours of debate over decimals and lab calculations, he accepts the consequence, signaling a turning point. This is a key moment of human drama, showing how someone wrestles with pride, logic, and inevitability. The judge acknowledges the decision, and the tension slowly gives way to resolution, making this part emotionally compelling and suspenseful.
I had a jury trial come up, not next week, the week after. We can get a jury trial. Is that what you want? You want to fight that issue of this extra 1,000th in the decimal point?
It's not an extra 1,000th though. It's 1,000th or it's not.
Okay, it's 1,000th or it's not.
Yeah.
You want to go to trial over that and have the lab analyst explain it? Because I'm going to tell you, she is far smarter than I am when it comes to science and to explain it to you. Then maybe you'll be able to understand. You won't be able to ask her questions.
How about this? Can I just go to jail and I'll give you this copy?
I don't need the copy.
Okay, and then just so give me the knowledge because I like math and
Here's what you can do to gain knowledge. Call up a lab analyst, have them explain it to you. Because that's what happens in a jury trial. And I hear it. It goes on for hours.
I'm not trying to
hours.
piss you off. Just take me to jail. I'm fine with that. I have the money finally at the last moment. You've been very giving, lenient with me, and gave me extensions. You're fair. And I'm here. And I'll go to jail, get out. I got a job. And
All right.
Fine.
So, are you admitting that you at least blew over a 0.08 or at least 0.08, at least blood alcohol content was in your blood at the bare minimum?
I agree that I blew a 0.221, and I agree that my blood alcohol was at 0.190.
Okay. All right.
I agree with those.
And do you agree that you operated or drove a motor vehicle
And
while in that state?
I agree to that, yes.
All right. Mr. Keen, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Your Honor.
Has anyone made any threats to you, Mr. Lamprecht? Any promises for you to plead guilty to this charge? Has anybody promised you anything? Hey, we're going to give you $1 million if you plead guilty. Or we're going to give you some kind of benefit if you plead guilty, other than this offer of guidelines.
The only thing that I've been told was that I can get out, keep my job, keep my place, and keep my things.
Okay, so that's not a promise. Anyone threaten you anything? I'm going to beat you up. I'm going to take a gun. I'm going to take a knife.
None of
Anybody threaten to hurt you or anything?
None of those.
Okay. Are you pleading guilty?
Now the defendant admits his blood alcohol content over the legal limit and confirms he operated a vehicle. The courtroom tightens as this acknowledgement solidifies the case against him. Every word carries weight because this confession is the turning point that validates all prior arguments. The judge and attorney make sure the defendant fully understands the legal stakes, creating a serious and impactful moment that keeps viewers glued to the screen.
With a full understanding of what you're doing here today?
Yes, I'm pleading guilty to blowing a .221 and having a blood alcohol content of 0.190.
All right. And you're pleading guilty voluntarily?
Yes.
Does anyone or are you satisfied with your attorney's services?
I guess 5 out of 10.
5 out of 10. Has he done a good job in the fact that he's looked to see if you had defenses? Because I'm going to tell you, your argument here is crap. I don't say crap in court, it's crap.
I'm just trying to conversate. I'm not trying to argue.
This isn't a conversate time, okay? This
Okay.
isn't a time to conversate.
Okay.
This is a plea and sentencing
Okay.
in which you showed up to court 18 minutes late.
Okay. I forgot my money. I apologize.
Has your attorney talked to you about the case?
Yes.
And has he looked at everything and discussed with you everything that he's seen in discovery?
Except for my one question.
All right, because he's not a scientist. But he said you can.
In this part, the judge ensures the plea is voluntary, confirming no threats or promises were made. The defendant and attorney discuss the factual basis of the case, including minor defenses, while the judge maintains strict control. This segment highlights the courtroom's procedural rigor and legal precision, showing viewers exactly how justice is structured. It's a tense, focused, and informative moment that sets the stage for sentencing.
Figure that out. Talk to a scientist, right?
I don't know any.
Mr. Keene, you said that's not a defense, correct?
Yeah, and yes, and we have discussed that in basic math and other things along with it extensively.
All right. Okay. You have any? No. All right. So, based on this, the OWI third, count 1, how do you wish to plead?
Guilty.
Court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 1. Count 2 will be merged and dismissed with count 1. A judgment of conviction will be entered today. Mr. Renicky, argument, please.
this is kind of amazing, but in any event, this is an OWI. There was bad driving, but no accident. As the court is aware, it's a .19 BAC. And this is his third OWI. He did complete the IDIP program. He still has to, at least at the time of my letter from Tessa Anderson, he had just dropped off the last $200 to complete the IDIP, but he needs to come up with a down payment for the electronic monitor as well as the booking fee. He was booked in a release, so he has not set the 48 hours. Because of the IDIP completion, inconsistent with the plea agreement, we would ask the court to follow the IDIP guidelines for the 1-9 on the third offense, which I believe is $1,911 for fines and costs. It's a blood draw, so there'd be a $10 blood draw, 45 days of jail.
Finally, we reach sentencing. The attorney outlines fines, jail time, community service, and future implications, emphasizing the rehabilitation and deterrence aspects. The defendant's compliance with the IDIP program is noted, and the legal consequences are firmly established. This segment resolves the tension of the courtroom drama while underscoring accountability. Remember to like the video, subscribe to the channel, and we'll see you in the next video.